So we'll now turn to Sally, and then we'll open the floor first to the committee for questions and then to others. Sally, whenever you're ready.
Okay, I have a PowerPoint, and can someone give me directions on how to click that? Oops. Can you hear me?
Yes.
We hear you. We're looking for the person to.
Hi, Sally. If you can share your screen, I gave you presenter rights already.
Okay. How do I share my screen? I'm sorry.
Go to Quick Start. Actually, go to the Share tab on the top.
Okay. My screen. Okay, let's see. Are you getting both? Are you getting my PowerPoint, or are you also getting my picture of you?
We're getting your PowerPoint. Oh? It's not quite full screen.
Okay. I apologize. Seem to be.
Yeah.
There. Is that better? Do you have full screen now?
You can do the slideshow view. It's, what are you?
There you go.
It's this thing. I can't click on it.
Right.
It's on the bottom right-hand side. There's like a screen.
Right to the
right there.
one right next to us.
Got it.
Excellent.
Okay.
All right, we're ready to go.
I'm Sarah Burns. I'm a professor of clinical law at NYU School of Law. I've been invited to speak with you because of my work with social science experts in discrimination litigation, particularly sex discrimination, sexual harassment, and hostile work environment cases. And also how to control sexual harassment in particular. I have some thoughts about bullying, and the similarities and differences, but I'm not a student, and so I'm going to stick to my own experience and hope that will be of help to you. As background reference, I have given you several trial opinions of cases in which we used expert testimony. One is the trial opinion in Hopkins versus Price Waterhouse. Another is the Supreme Court decision in Hopkins versus Price Waterhouse. And the third is a trial opinion in Robinson versus Jacksonville Shipyards. These will give you some sense of the relationship between the factual and expert proof that we put on, and also the judge's responses to the use of that proof. These cases were cases that were developed and presented in the mid-1980s into the early 1990s and actually helped establish the doctrines that guide the harassment law that I think is now referenced in your material. I've also given you two friend of the court briefs. One was the brief of the American Psychological Association submitted to the U.S. Supreme Court in Price Waterhouse. The other was a brief of 42 social psychologists submitted in NAACP of Maricopa County versus Horn, and that was submitted in spring of 2014. This was a case in which the question was plaintiff standing, and from the plaintiff's standpoint, it turned on the question whether group stigma is a concrete injury to group members. A number of prominent social psychologists in the U.S. supported that brief. It was an effort led by Dr. Brenda Major, and it was joined by this committee's Dr. Mark Hatzenbuehler. The table of contents and of the two amicus briefs are a good index of the literature that I'm referring to, and also give you some idea of the relationship between the literature and the legal issues in cases, in these particular cases. In my view, the use of social science evidence in court is not only important in proving cases, but also in public education and feedback to scientists themselves. This is not, however, routine forensic testimony. It requires original work of scientists willing to really dig into the relationship between the work that they're doing and the real world. And in that difficult work, for those who have done it, I am very grateful. So speaking now as a plaintiff's attorney representing the target or victim of discrimination, I actually find that social science has three uses, and they're all very powerful uses. So the first is in case discovery and case planning. In my experience, the social science actually points in the direction of things that we need to look for as lawyers in developing our cases. I also use the social science a lot in case argument, and by that I mean pleadings, briefing, presentation of opening, closing statements, and so forth. And I just have given you a list in the PowerPoint of various social science sourcing and research that I've gone to. I specifically remember going to in preparing materials for cases, and this is about the wordsmithing of the cases. In particular, in simple terms, the question really is how to present the case such that the decision maker's own biases aren't automatically working against the plaintiff. And in my experience, that typically means a story of a world in which the plaintiff is included and belongs. To get acceptance of that worldview, the decision maker has to believe that troubles can be fixed. And in that regard, I found that the social science expert testimony can be significantly helpful. So turning to probably what's of the greatest interest to the committee, how we used expert testimony in a couple of, in these two particularly prominent cases. The first is Pricewaterhouse, and as you know, in proof of discrimination cases, a central concern, without which you don't have legal liability, is proving that the harm was done because of the target or victim's protected group membership. This was certainly the purpose of the testimony, Dr. Susan Fisk's testimony in Pricewaterhouse. And let me just digress for a minute and tell you briefly about the facts in that case. Ann Hopkins had brought in more money and clients than the remaining 87 partner candidates, all of whom were male. Nonetheless, she was passed over. And when she was passed over, her strong supporters, those who believed her work was good and that she was worthy of partnership, advised her to hang on for another year and in the meantime to wear more makeup and jewelry and to walk more femininely and talk more femininely. And this was, of course, the explicit proof, which oddly came, sort of the smoking gun proof, which oddly came from her supporters. Obviously, in sex stereotyping research applies here. No one would tell male candidates to wear more jewelry and to walk more femininely. And also the role strain, or the sort of classic catch-22 for women in a competence work situation, that a competent woman isn't a feminine woman and femininity does not bespeak competence, concerns about which men don't have to worry. Another factor was that she was the only woman, which meant that she was under heightened scrutiny, and her differences from males in the same situation were even more emphasized. This put her under a great deal of stress, although I don't think that was part of the testimony in Hopkins. There was a key moment in the testimony, and I think this is relevant more to the backstory of developing use of expert testimony in cases, and that was a point at which we got to the idea of intent, which is slightly an anomaly in Title VII cases. The statute is written around the question whether the harmful action was based on sex, which is a pure causation question. But the case decisions talk in terms of discriminatory intent, which in common sense terms implies consciousness as a requirement for discrimination action to be wrong. You can see the irony. If consciousness is required, we are probably least able to prove legally challengeable discrimination in the context where discrimination is most extensive. In using sex stereotyping literature, and if you look at the sex stereotyping research, it's frequently said that stereotyping, like many cognitive processes, is a function of cognitive efficiency, and therefore is something that occurs mostly below consciousness. During the testimony in Price Waterhouse, Judge Gazelle, the trial judge, specifically leaned over to Dr. Fisk during her testimony, and he asked her, do educated men like doctors, professors, teachers, and lawyers do this, meaning do they sex stereotype? And the answer that Dr. Fisk gave was, of course, yes. And then he asked, is it intentional? And this was a key moment, and her response was that the question of intent is a legal question that social science to which social science does not have a direct corollary. But she pointed out that it is observable and that there are things that can be done to control it. And he actually used that analysis. And I would just say that there is a backstory here. I worked with Dr. Fisk in 82, 83, originally on a different case that settled, and we had explored this question, after which she did research to determine how and under what conditions cognitive control is likely and how it can be facilitated by motivational intervention. It was important, by the way, in the use of this kind of very novel and groundbreaking use of social science research, it was important that we had a good judge, and Judge Gazelle was known to be a smart, careful judge who was somewhat bored and likely to want to make good law. Ultimately, the Price Waterhouse case went to the Supreme Court on a question of who bears the burden of proof in a mixed motive case. The mixed motive in that case was Hopkins denied partnership for her sex, or was it because she lacked social grace and skill? Congress actually got involved after the Supreme Court decision came down and answered that question by amending Title VII such that liability is proven, that if you prove that there was some factor of sex or protected group membership, liability was attached, and the remaining questions went to remedy. So Jacksonville Shipyards, how am I doing on time?
5 minutes.
Thank you. Jacksonville Shipyards occurred, it was a mid-1980s case. We were really working against the backdrop of a normative culture that accepted injurious behaviors as being natural or the product of what is. Bad behaviors by perpetrators were routinely dismissed with familiar phrases like boys will be boys, and targets who complained would get responses like don't be too sensitive and you brought it on yourself. So the primary task at the time was not to prove an occurrence, but to prove its legal significance and to persuade courts of its legal significance. I did not have sexual harassment cases in which there was direct, persistent targeting that sometimes happens in those cases. If I had, I probably would have gone back to the Milgram and prison studies and worked forward to research on group dynamics how group dynamics influence abusive behavior, and then research on what interrupts abusive behavior. But as it happened, I didn't have those cases. What I did have were non-traditional work environment cases, and particularly in the Jacksonville Shipyards case, women were 5% of the workforce. And as a result, the research on what's often referred to as solo or token status became quite an important body of research for us. There's token status when an observably different group represents less than 15 to 20% of the population in the setting. Token status is a perceptual phenomenon. That is, the perception of the majority is heightened around the minority status. So it facilitates categorizations. In the workplace, women were highly observable and were seen as women, viewed more similar to each other and distinctly different from the majority. If there were differences among women that were noted, the differences always fell along a continuum of femaleness. So in the shipyards, there was the slut, the bomb, the bull dyke, and the girl next door. And those were the women in the workplace. being under this kind of stereotypic scrutiny is extreme pressure, and it's very stressful. That pressure and that scrutiny served to divide and isolate the women, so they became critical of each other. We used the expert testimony to explain this to the court. Context was important in other ways as well. There were dispersed work sites. Employees typically worked without supervisors present. There were sexual pictures in the gathering places where people got their assignments in the morning and when they checked out at night. And then pictures, sexual pictures would arrive when a woman was assigned to a particular location, suggesting that there was a certain amount of targeting in the use of pictures. And there was also, of course, testimony about various kinds of sexualized behavior. Once we developed a day in the life at the workplace for the women, then we had Dr. Fisk testify. And ultimately, she cited a priming study, which had been done with an experimental condition in which they showed softcore porn to men, college-age men, and a control condition in which they showed the Canadian Parliament. And the punchline on that was that 50% of the softcore porn condition men behaved sexually toward the female debriefer, and an insignificant number, and certainly a statistically significant difference in number for had sexual behavior in the Canadian Parliament condition. So let me see if I can catch up on my, there we go. Yeah, another question, of course, in these cases is who's responsible? And in the Jacksonville shipyards setting, because the behavior was mostly the known behavior was by co-workers, and the question of employer responsibility was failure to take action, of course. And I'm hearing analogs in Craig's recounting of the bullying law. I would just say law isn't, litigation in particular, isn't particularly good at providing a remedy for dignitary harms. Although media tells stories of million-dollar verdicts, this is quite uncommon. But I think there's no question that social science has powerful evidence to offer. And in this regard, I would draw your attention to the NAACP versus Horn brief that I've given you, the review in part 2 of that brief on the injury rendered by stigma. There are 3, I think, really useful highlights of that recent research. One is that stigma is harmful, is shown to be harmful to the physical and emotional health of stigmatized group members, and it interferes with cognition and thus, obviously, performance. Second, group stigma is even more harmful than individual shaming. And the third point that comes out in that work is that environments of high stigma correlate with higher negative cognitive, emotional, and physical health effects, including higher mortality of the stigmatized group members. I'm happy to answer questions at the end of this panel, and I'm also happy to take questions at any other time by the committee. Thank you.
Thank you very much, and thank you to all 3 of our speakers. So I'll open it up to questions from the committee first.